Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke, and this is the ultimate guide to the rules of evidence in mock trial. If you want to excel at objections in mock trial, whether you're in high school or college, there is no substitute for a stone-cold knowledge of the rules of evidence, and that's what this video is designed to give you. We're going to go through each of the most common rules of evidence, lay out exactly what the rules say about it, how you can have a firm understanding of it, and more importantly, how you can take that into the courtroom and argue it well. It's all going to start with relevance. Relevance is one of the most common rules that you'll deal with over the course of mock trial. It's one of the most common objections that you'll see, and you need to know what it's all about. Here we go.
We're going to talk about relevance, and we're going to do three things with relevance. We're going to explain what the rule for relevance says and what that means. We're going to talk about when you should make relevance objections, and we're going to talk about how you should respond to relevance objections. Ready to go? Let's do it. So here's the thing about relevance. We're going to pull up what the federal rules of evidence say about what relevance is, but don't we all kind of know what that word means? I mean, there are some other legal words that you would have to be a lawyer or have to have done mock trial before to know what they mean, but relevance is a word that we use in our everyday conversation. I mean, if you're having a discussion with a friend in a classroom or at your house, you've probably said something before like, well, that's not really relevant to the situation, or, well, how is that relevant? So we know what that word means. We know what relevance is in terms of its definition in the English language. So when it comes to mock trial and it comes to objections, it's just about putting a few key words to the definition of relevance to help us make arguments clearly about what is and is not relevant. So let's take a look at what the federal rules of evidence say about relevance. Here's a look if you're listening on YouTube. Evidence is relevant if it A, has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. So that's a lot of legal gobbledygook, and quite frankly, some of those words you don't really even need to memorize because they don't come up. I got through my entire mock trial career without memorizing some of those words. Others of those phrases are a little bit important, and there's three of those, and we're going to talk about what they mean right now. So the first phrase I want to talk about that's really important when it comes to relevance is one of those first phrases in the rule, any tendency. Relevant evidence is evidence that has any tendency. Okay, so what does any tendency mean? Well, if something has any tendency to do something, it means that there's a chance for it to happen, right? I mean, for example, I often shop for groceries at Walmart or Kroger, two of the grocery stores I have in my hometown, but I very rarely shop at Publix, another grocery chain we have here. Now, I do go to Publix sometimes because I like their chicken, I like their hot deli, but I don't go there a whole lot. So would we say that I have any tendency to go to Publix? We probably would, right? Because there's a chance that I would go to Publix. Now, if you heard that I'm shopping for groceries, would you say that it's likely that I'm going to Publix? Well, probably not. That takes things to another standard. But if we're just saying any tendency, all we're asking is there a chance? So if I'm shopping for groceries, is there a chance I'm going to Publix? Is there any tendency I'm going to Publix? Probably so. The next phrase I want to look at is more or less probable. Here's all that really means. More or less likely. Relevant evidence makes something else more or less likely. Now we're going to talk about what that something else is in just 1 second, but if we're thinking about more or less likely and something affecting something else being more or less likely, let's think about it this way. If I'm taking a walk on the side of the road at night, does wearing a bright yellow shirt make it more likely that I'm going to be safe and that I'm not going to get hit by a car? Of course it is. And if I have a blinking light on my forehead, it's going to make it even more likely that I'm going to be safe. But if I'm wearing all black and I'm blending in with my surroundings and drivers can't really even see me, it makes it less likely that I'm going to be safe. So when we think about relevant evidence, we have to think about it in that context of more or less probable. But I think it's pretty clear what that means. Again, all it is more or less likely. Does this make that more or less likely? And finally, the third important phrase we want to think about with relevance is the fact is of consequence. So we have that relevant evidence is evidence that has any tendency, in other words, it has a chance to make a fact more or less probable. Does this make that more or less likely? What kind of fact are we dealing with here? That's what the B part tells us. It says that it's a fact of consequence. And here's what a fact of consequence means. It matters to the case. A fact of consequence is something that matters to the case. And it doesn't have to be the ultimate issue, right? If we're in a murder trial, the only fact that matters to the case isn't just that Jenny killed Johnny. There are other facts that matter too. For example, if we're saying that Jenny killed Johnny with a certain type of handgun, don't we think it matters as a fact whether Jenny had any access to that handgun, whether she owned one or one of her friends owned one that they let her borrow? Right? There are a lot of facts in a trial that matter, but with relevance, we're dealing with evidence that has any tendency, again, any chance to make a fact more or less probable, more or less likely. Does this improve or not improve the chances of that? And the fact that we're talking about, the fact that relevance has to make more or less likely, is a fact of consequence, a fact that matters. So all of those words, all of the legal gobbledygook, everything we just went over, points to the very definition of relevance that you knew coming into this video. Relevance is something that pertains, right? It's something that has to do with what we're talking about in a trial. But these words are the words that the writers of the rules of evidence give us to help us understand what relevance is. So let's pull back up Rule 401, the rule for relevance, but let's substitute in some of the definitions we just talked about to give ourselves a simplified, easier to understand definition of relevance. So evidence is relevant if it has a chance to make a fact more or less likely. Again, does it make this, does this make that more or less likely than it would be without the evidence? And the fact, the thing we're talking about, is of consequence. In other words, it matters in determining the action. In other words, the fact matters because it affects an element or the credibility of a witness. So that's all relevance is. Now, you might want to go back and rewatch that section of this episode again a couple of times, maybe even, to get yourself in the right headspace for understanding what relevance is. But again, all those words point to the definition of relevance that you knew coming into this video because that's a word we use in our everyday English language. So now that we know what relevance is from a legal standpoint, let's talk about when we should make relevance objections. And the answer to that question is pretty rarely. You see, because relevant evidence just has to have any chance to make something more or less likely, and a lot of things have any chance to make a fact that matters more or less likely. And that being the case, a lot of stuff is relevant, and very few things really aren't relevant. So here's what you can do to decide in the moment, should I make a relevance objection? And I learned this strategy in the excellent mock trial book, Winning Objections, a Mock Trial Guidebook. Everyone should go order that book. I'll leave a link in the description and show notes for doing that. What that book teaches is that you should use the eye roll test. If you're listening to a witness testify and you're sitting there rolling your eyes like, oh my gosh, when is this going to end? What in the world are they talking about? Why in the world are they talking about this? Right? Make the relevance objection. At that point, you've probably crossed the threshold into things that don't have any chance at all to affect something in the case, to make something in the case more or less likely, an element of the law or the credibility of a witness. But if a witness is talking and you haven't gotten to that point, you're not rolling your eyes, you're sitting there thinking, maybe this is helpful, okay, right? You probably shouldn't object to relevance. And the reason that you shouldn't object to relevance is that relevance objections are super easy to respond to, and most of the time the attorney responding is going to win. How do you win relevance objections with your response? Let's talk. So how do you win relevance objections? How do you respond to relevance objections? Explain why the thing matters, right? So if evidence to be relevant has to have a shot at making something that matters more or less likely, what you need to do is tell the judge why the thing makes the thing more or less likely. So let's go back to our gun example. Let's say that you're offering evidence that Sheila, the person accused of killing Johnny, and I keep changing the names, I know. Sheila, the person accused of Johnny, had access to this murder weapon, and the other side stands up and says objection to relevance. Well, you're going to stand up, you're going to return to the rule. That's the first thing you always do in responding to objections. You're going to say, Your Honor, the rule for relevance, or Rule 401, says that evidence is relevant if it has any tendency to make a fact of consequence more or less likely, or more or less probable. And then you're going to say, and here's why this evidence does that. If Jenny had access to the handgun, or whatever I said the person's name was, I've honestly forgotten at this point. If that person had access to the handgun, then that means it's more likely that they had the ability to murder such and such person. Right? It's super simple. When you respond to relevance objections, once you return to the rule, once you do the RTR that I talk about in my video on arguing objections, all you've got to do from that point is explain why the fact is important, or why it has any chance to be important. Because I really shouldn't even use that word. Relevant evidence doesn't have to be important evidence. It just has to have a chance to affect something that matters. And because of that, because that barrier is so low, I would go so far as to say that attorneys should never lose a relevance objection when the other side makes it. Because if you can't explain why you're asking the question, which is really all we do in a relevance response, we're saying, why does this matter? Or why could this matter? Why are we asking the question? If you can't do that, then you shouldn't be asking the question in the first place. So if you're only asking relevant questions, which are the only types of questions you should be asking, you should never lose a relevance objection, especially if you study the framework of the rule like we've talked about in this video. So you may not feel quite like an expert on relevance at this point. And look, I get that. The rules of evidence are difficult. It takes some time to absorb them all and get confident with it. So feel free to go back and watch this video again, go through it a couple of times if you need to, and that'll give you a good foundation for relevance objections. Talk to your coach, schedule coaching with me if you'd like to, and that's what will help take you to the next level. Because if you want to be a mock trial master, you've got to know how to argue objections, and knowing the rules of evidence, and this one in particular, relevance, is the first step to doing that.
Next up is hearsay, and this is one you may have heard of outside of the courtroom. Sometimes if someone is gossiping, you might respond and say, well, this is all really just hearsay. How do we know that it's true? Great question to ask, and that's why generally hearsay is not allowed. And now you're going to see exactly the specifics behind what hearsay is, what hearsay isn't, and how to argue the rule in your next trial.
So I'm going to start by throwing the definition of hearsay up on the screen if you're watching on YouTube, and we're going to talk about it together and talk about what some of these words mean. Here it is. The hearsay rule comes to us through Rule 801C, and it says this: hearsay means a statement that, 1, the declarant does not make while testifying at the current trial or hearing, and 2, a party offers in evidence to prove the truth of the matter asserted in the statement. So I want to start off by defining 3 words in that rule that I think are immediately going to help us all get a much clearer understanding of what this rule is talking about, because that's really like big-time lawyer language that we just read, but some of the words in here are words that I promise you know. Let's start with that first word. Hearsay is a statement. Let's think for a second about what a statement is. By the very nature of that word statement, a statement is something that states something. A statement isn't a question that's asking for information. It's not a command that is just telling someone what to do. A statement is a type of sentence that states something. In other words, there is information being passed along in the statement, in the sentence. Right? If you want to think about the types of sentences you learned about when you were in grammar school, a statement is a declarative sentence. It is a sentence that is declaring something. There is something being stated. If there's not something being stated, then it's not a statement. So the first thing that tells us about the hearsay rule is, though it's applying to things people say, which you probably already knew, right? Hearsay is applying to things people say, hearsay, it only applies to statements. It doesn't deal with questions, and it doesn't deal with imperative commands. So that's the first part of the hearsay rule that we can talk about. The second word I want to highlight from the definition of hearsay is declarant. Declarant is a fancy word that just means the person who said the thing. So everything that you're hearing right now in this video or in this podcast, if you're listening on a podcast platform, the declarant of all of these things is me, Luke Worsham. I'm the one saying all of these things. I am the declarant. Here's the thing too. If you then go to your friend and say, hey, I was listening to this mock trial podcast and this guy named Luke said these really interesting things. Here's what he said. Even you in that moment quoting those things, I am still the declarant of those statements because you're passing along what I said. So I know this might be tricky, but even though you in that moment would be saying the words, what you're really doing is you're quoting words that I said. So the declarant, when we think about it in the context of hearsay, the declarant is the person who originally said the thing. If someone is quoting someone else, if Mark is quoting John, John is still the declarant, even though Mark currently might be speaking. Does that make sense? Right? The person who originally said the thing is the declarant. If I were to quote the I Have a Dream speech for you right now, Martin Luther King would still be the declarant of that speech. If I were to quote the Gettysburg Address, 77 years ago, our fathers, blah, 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 Abraham Lincoln is still the declarant of the Gettysburg Address. Declarant means the person who said the thing, but within the context of hearsay, specifically, declarant means the person who originally said the thing. A lot of times it means the person who is being quoted. Another important term to define from the hearsay rule is the term the matter asserted. This one sounds really big and fancy, but it's actually pretty simple. See, the matter asserted in a statement is simply the thing that statement is asserting. So let's say I were to tell you, hey, I think it's going to rain outside. What am I asserting in that statement? I think it's going to rain outside. If I were to tell you that the Civil War took place in the 1800s, wow, we've got a lot of Civil War references in this video. If I were to tell you the Civil War happened in the 1800s, what would I be asserting with that statement? Because remember, statements have truth in them. Statements say something. They convey information. The thing I'm asserting in that statement, the matter asserted in the Civil War happened in the 1800s would be, you guessed it, that the Civil War happened in the 1800s. See, the matter asserted in a statement is just the thing that statement conveys. Because remember, statements convey information. Statements convey something. And so the matter asserted is simply that thing that the statement is conveying. It's the matter being asserted by the declarant who gives the statement. See how all of this starts to fit together? Okay, so at this point, let's recap. Here's what we've got. We know that hearsay must be a statement. For something to be considered hearsay, it must be a statement. All right? It has to convey some kind of information. We also know that it's going to have a declarant. There's going to be someone who said this thing, more specifically, someone who originally said this thing. Even if we're quoting someone, we're still only concerned with the person who originally said the thing. And we also know that it's got something to do with the matter asserted, the actual thing being declared, the actual statement being made, the information being conveyed in the statement. That's going to be important too. Right? We know all of those things. And there's one other component we can look at, which is at the end of the rule where it says, other than one made by the declarant while testifying in court. That's a lot of words to mean one very, very simple truth, and that's this. The hearsay rule only deals with out-of-court statements. Things that witnesses say while they're on the witness stand and they're sworn in court, those are going to be fair game. The hearsay rule only deals with statements, only deals with sentences and things being said that convey information, and they only deal with statements that happened outside of the courtroom. Those statements also had a declarant, a person who said the statement, and we know that they have to have asserted some kind of truth, otherwise they wouldn't be considered a statement and they wouldn't be eligible under this rule. There's one more phrase we're going to have to look at that's going to finish the box for us, that's going to put a bow on top and help us to really understand all of these concepts. So what I would recommend at this point, because hearsay can be complicated and all of these rules of evidence take some time to digest. This isn't something you can always grasp, by the end of the day or by tomorrow. Pause the video, go back to the beginning where we started talking about this definition and refresh yourself on some of those terms. Then come right back to this point, go ahead and mark the timestamp, come back to this point, and then let's put a bow on the box. All right, we've talked about declarants, we've talked about the matter asserted, we've talked about statements. Let's put a bow on this whole thing. So hearsay deals with out-of-court statements made by a declarant that are being offered in court, this is the last part of the rule, for the truth, to prove the truth of the matter asserted. So let's put a bow on this by explaining what that phrase means. You know what the matter asserted means. It just means the literal thing being declared by the sentence, the actual thing being stated, the information being conveyed. So even if a statement was made out of court, it has a declarant, and it is indeed a statement, for it to be hearsay, the party who is offering the statement must be doing so to prove the truth of the matter asserted. In other words, to prove that the matter asserted, the thing being stated, is true. So let's go back to some of our earlier examples, right? Use the phrase, it's raining today. If for whatever reason you were in court offering the fact that I said it's raining today, right? It's an out-of-court statement. I made it while shooting this video, not while in a courtroom. There's a declarant, it's me. It's stating a truth, right? The fact that it's raining today. But it's only hearsay if the reason you're offering that statement, or if the reason your opponent was offering that statement, would be to prove the truth of what I asserted. Now remember, what I asserted is that it's raining today. So if someone is proving the truth of that statement, what it means is the reason they're offering the statement is to prove that it was in fact raining that day. In that situation, again, the statement was a statement. Right? It's not a question. It's not a command. It was made out of the courtroom by a declarant, me. And in that situation, if you're trying to prove that it was raining for whatever reason, you would be offering that statement to prove the truth of the matter asserted, to prove the truth of the thing I stated, and therefore it would be hearsay. That's how this rule works. Now, you've probably got a question, and it's a great one, which is, so what does it look like when a statement that was made out of court and has a declarant and is a statement is not being offered for the truth of the matter asserted? Well, let's do this scenario. Let's say that for whatever reason we're in a town where it is illegal to have umbrellas, and I'm on trial for having used an umbrella. So we go in the courthouse, and I'm on the witness stand, and I make the statement to the jury. I look them in the eye and say, actually, I didn't even know it was going to rain that day, so how in the world could I possibly have an umbrella? Why would I have even brought one with me that day? And then you get on the witness stand and you said, actually, I was talking to Luke that morning, and he told me it's going to rain today. Now, let's hold up for a second. In that situation, would we really care if it was actually going to rain that day? Because here's the deal. We can probably get that information from other people. We could probably use a weather report. We could probably use people who were walking around that day who said, yes, I was there and it was raining, and we wouldn't have to use a quote. We wouldn't have to use a hearsay statement. And so in that moment, when you were on the witness stand after I've said, didn't even know it was raining that day, and now you're on the witness stand and you're saying, actually, he told me it was going to rain that day, what I would argue is that you're not actually trying to prove the matter asserted. You're not trying to prove the truth of what I said, which is that it was raining. You're simply trying to prove that I'm a liar. What you're trying to do is prove not that it actually was going to rain, because really, who cares? What you're trying to prove is that I did, despite what I said earlier, know it was going to rain. You're trying to prove what was in my head. You're trying to prove what I believed, not the truth of what I actually said. And in a situation like that, the statement would not be considered hearsay. Because, again, for something to be hearsay, it does need to be out of court, there does need to be a declarant, and it does need to be a statement that is conveying information of some kind, but it only counts as hearsay as if the truth being, or if whatever's being asserted, but it only counts as hearsay if whatever is being asserted in that statement, the truth of the matter asserted, is what you're trying to prove. This is a lot to take in. I know that. So like I suggested earlier, go back, rewatch this video, go back through it again, and I think the more times you go through this, you'll start to get the picture of that's what hearsay is. And once you get that picture of hearsay and what it is and what it isn't, you'll be on your way to arguing the hearsay rule like a mock trial master. If you have any comments or you want to dive further into hearsay, you can pick up my book. Feel free to shoot me an email, leave a comment below this video, Or if you want to schedule coaching with me and you or with me and your team, you can do that as well by clicking the link on YouTube or in the description on podcast platforms. I can't wait for you to start arguing hearsay like a mock trial master, and I can't wait to hear about it when you do.
Up next is Rule 403, and this is a type of objection that doesn't have a cute little word attached to it like hearsay, relevance, something like that. We just know it by the rule because it's a little weird. But though it may be weird, it's not hard to understand. You just need to know the basics and take the rule piece by piece. That's what we're going to look at right now.
So the best place for us to start as we break down Rule 403 is with Rule 403. Let's read through the rule together. Take a look. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So that list at the end is very long, and a lot of that can be very important, but what I want us to focus on just for right now is that first phrase, unfair prejudice, or the danger of unfair prejudice. We can worry about the rest of them some other time, but we're going to be concerned about unfair prejudice in the context of Rule 403 in this video as you try to wrap your mind around the rule and what it means. So let's now dive into breaking down some of the terms we saw in that rule, which was a little bit like alphabet soup. Let's be realistic. We're going to start by breaking down the first term you saw, relevant evidence, right? The rule started by saying that the court may exclude relevant evidence, ... And what that tells us right out of the gate is that Rule 403 deals with evidence that is relevant. Now, if you're not sure what relevance means, you can go check out my video that breaks down relevance and Rule 401. But if you do know what relevance means, you know that relevant evidence is evidence that has any tendency to make a fact or consequence more or less likely. So that's the type of evidence that we're dealing with when we make Rule 403 objections, because the rule tells us right off the bat that this is relevant evidence. The next term I want to look at is probative value. If you've read my book, you know that I talk about how relevance is a binary concept. There's no such thing as one piece of evidence being more relevant than another. That's because something is either relevant or it's not relevant. There's no such thing as a degree of relevancy. It either is or it isn't. With probative value, though, which is the term we're looking at right now, there are degrees. See, while the term relevance tends to ask with a piece of evidence, could this be useful? Right? Does it have a tendency to make a fact of consequence more or less likely? The term probative value asks, how useful is it? See, probative value is a measure of the usefulness of evidence. When we're saying, what is the probative value of this piece of evidence? We're saying, how is it useful and how useful is it? So, Rule 403 says, relevant evidence, evidence that is relevant, may be excluded, in other words, may not be allowed, if its probative value, in other words, if its usefulness, if how useful it is, the next term we're going to look at is substantially outweighed. Now, this is a term I don't have to explain to you. You know what substantially outweighed means. You know that an elephant substantially outweighs a brand new puppy dog. You know that a giant piece of living room furniture outweighs your smartphone, substantially so, right? So substantially outweighs means, number one, it outweighs something. There's a big weight difference, but it's not just a weight difference. It's a huge weight difference. It's a substantial weight difference. So let's go back to the rule. Relevant evidence, evidence that's relevant, may be excluded if its probative value, in other words, its usefulness, is substantially outweighed. In other words, it's not even close on a scale, by the danger of unfair prejudice. So let's talk about that term, danger of unfair prejudice. Now, what you need to know at first is that every piece of evidence that gets presented in a trial has prejudice and has a prejudicial effect, if you will, on the jury. Right? If I'm trying a murder case and I present evidence to the jury that the defendant owned the murder weapon, that the murder weapon belonged to the defendant, okay, well, that evidence is going to prejudice or persuade the jury into thinking the defendant is guilty. Right? But if I were prosecuting my case, that would be my job. It would be my job to present that kind of prejudice to the jury. The problem becomes if we're using prejudice that's not fair or that's out of line. In other words, prejudice that's a little bit slimy. So there's a natural question that follows from that, which is, how do we know what type of prejudice is fair and which type of prejudice is not fair? Very simple answer to that question. A piece of prejudice or prejudicial evidence is fair if it's going to persuade the jury on the basis of facts, right? So that example I just gave, the defendant owned the murder weapon. That is a potential fact I could present, and upon hearing that fact, the jury would find it more likely that the defendant committed the murder, right? We're dealing entirely with facts. But what if I started to present evidence that wasn't based in fact so much, it wasn't going to get the jury to consider a fact, but maybe instead was going to get them to consider their emotions? What if I started to point out bad things about the defendant? What if I just started hurling out evidence to prejudice the jury and to just not liking the guy? And as a result, they go to the deliberation room at the end of the trial, and they're talking and they're saying, well, the facts of the case don't really point to the fact that he did it, but man, he just seems so slimy and I didn't like him, so let's convict him. Is that how our justice system in America works? Right, no, obviously not. Right, we want juries making factual decisions, and that's why this Rule 403 exists. See, the type of prejudice we just talked about, where we're having a jury consider things not based on facts, a fact like he owned the murder weapon, but an emotion like I don't like him, I don't feel good about him, that's unfair prejudice. Unfair prejudice is any type of evidence that gets a jury to consider the case on a non-factual basis. We want a jury to be completely engaged in the facts of the case, not in how it makes them feel, and not in how the people involved in the case make them feel. And that, again, is why Rule 403 exists. But don't think at this point, as we've just discussed this, that Rule 403 excludes any evidence that might make a jury make an emotional decision, because that's not entirely true. We've talked about more components of the rule than just that. So let's go back to the rule as a whole and then re-break it down now that we know what some of these terms mean. Relevant evidence may be excluded if its probative value is substantially outweighed by a danger of unfair prejudice. So, again, we have evidence that is relevant, but that evidence, even though it's relevant, is not going to be allowed if its usefulness, its probative value, how useful it is substantially outweighed by the danger of unfair prejudice. In other words, the danger of causing the jury to evaluate the case on a non-factual basis. Rule 403 at the end of the day, guys, is a balancing test. I love, whenever I'm teaching Rule 403 to my students, to write something like this on the marker board, which is a scale. It's balancing the probative value or usefulness on one hand, and then on the other hand, the danger of unfair prejudice, the danger of having the jury consider the case on a non-factual basis on the other hand. And what you're doing when you make a Rule 403 objection is you're weighing those two things. You're balancing those two things, and you're seeing what's the balance there. Is the usefulness substantially outweighed by the danger this evidence has to make the jury evaluate the case on a non-factual basis? So let's think of a couple examples, right? So maybe we're in a murder trial, just because that's a really simple example to follow mentally, and we as the prosecution are presenting pictures of a bloody, maimed, dead body. Okay, now as the prosecution, one of our responsibilities in a murder trial is obviously to prove that someone died, right? You can't have a murder unless someone died. So we're just showing the court these pictures of a dead body to check that box, say, hey, yeah, someone died. We got to prove that. So it's relevant, right? It hits that bar. But remember, with Rule 403, we're dealing with relevant evidence, so that doesn't matter. The question we're going to ask is, number one, how useful is it? What's the probative value? That's the one thing we're going to weigh. And then the other question we're going to ask, the other thing we're going to look at is, What's the danger it has to unfairly prejudice the jury, to force the jury to make a decision on a non-factual basis? So our probative value in the case of these pictures of a maimed, bloody, dead body is, okay, we as the prosecution have to prove that someone died. That's our probative value. Now, there are probably a lot of ways we could prove that. We could prove that someone died simply by having a witness testify to that fact. We could prove that with a death certificate that doesn't involve any bloody pictures. And so as the defense, they might make a Rule 403 objection and say, Your Honor, we realize that there is relevance to this and there is some probative value, but it's very little because there's a number of other ways they could prove this. And then on the other hand, what's going to substantially outweigh that is the danger it has to inflame the emotions of the jury and get them to ignore the facts and just make a decision based on their feelings. I mean, think about it. If you're sitting in a jury in real life and you start to see pictures of a bloody, maimed, dead body, that's going to make you feel a certain way, right? It's going to get a rise in you. You're not going to like that. You're probably going to get angry about that, about the fact that this person in this case died in that way. But as Americans, as a society, with this justice system we have, we don't want juries going to deliberate cases in an emotional state or an angry state. And so that type of evidence, pictures of bloody, maimed, dead bodies, is exactly the type of evidence that Rule 403 is designed to keep out. Because without Rule 403, it's coming in. It is relevant, right? We proved that very small barrier, that somewhat of a probative value that it has. But I think you would agree with me that in this situation, that limited probative value, in other words, its limited usefulness to the trial, is substantially outweighed by the danger it's going to have to unfairly prejudice the jury, to get them to consider this case on an emotional basis instead of a factual basis. And that's what this rule is all about. Rule 403 asks, is the probative value, the usefulness of the evidence, substantially outweighed by the danger it has to be unfairly prejudicial? And if the answer to that is yes, then the evidence is not coming in. Now, there's a lot more we could get into about arguing Rule 403 well and some traps to avoid when you're making 403 objections, and we'll cover that in a later video down the road. But for right now, I just want you to focus on understanding what the rule means. If you're still a little bit lost, if there's still some cobwebs, don't worry, it's very complicated. Go back to the start of the video, watch it again. It's just, 10, 15 minutes long. You have the time in your day to do that. And really dig into this rule, because I promise if you spend some time with it, you will understand it. Another thing I would recommend is picking up a copy of my book, Mock Trial Masterclass, not because I just want to sell a book, but because there's an entire section in this book devoted to not just Rule 403, but every one of the major rules of evidence. And so if seeing it in this form has made you say, okay, I'm kind of getting there, I'm kind of understanding it, maybe seeing it in another form like this book will help you get all the way there. And if you want to pick up a copy, you can do that by clicking the link in the description on YouTube or in the show notes on podcast platforms. But I know you can understand Rule 403. When I competed, had the hardest time grasping this rule, and I eventually got there, and I know that you can and will too.
Up next is improper character evidence. This is honestly a rule that when I started competing in mock trial as a high schooler, it took me a while to fully understand. But here's what I'm going to promise you. It is not as complicated as some people want you to believe that it is. I think one of the reasons it took me so long to get a grasp of the rule is that it had never really been explained to me in a simple way. I was so stuck at looking at the actual rule and getting really confused by what it meant and what it didn't mean. And so what you're going to get right now is the simplest possible breakdown of improper character evidence. But though it's simple, it is accurate too, and you're going to understand this rule super well after taking a look.
So I want you to imagine this scenario. Imagine that years ago you were a bank robber, robbing banks all the time, in and out of jail for those crimes. But since then you have been released from prison, you have turned your life around, you've gone to counseling, you met someone and got married and started a family, and you've left your previous life of being a bank robber completely behind. But one day the police knock at your door and they say, hey, there's been a bank robbery nearby and we think you did it. And you ask them, well, what makes you think I did it? They said, well, someone robbed the bank and you used to do that, so it seems like a pretty good chance you did it. So you get dragged into the courtroom and you're there in your trial, and while you're on the witness stand, the government's attorneys start bringing in all this evidence about your previous bank robberies, neglecting the fact that you've turned your life around, neglecting the fact that it's been years since this happened. The jury hears all of this information, and because you robbed banks in the past, they now believe that it's more likely that you would have done this in the future, and they find you guilty. Now, do you think that would be fair? Right? Do you think it would be fair for a jury in that situation to hear evidence about your former life as a bank robber? Probably not, right? Because you've turned your life around and it's been a while since those types of things have happened. It just doesn't seem fair for that to come in. Well, the folks who wrote the rules of evidence agree with you and me on that point, because improper character evidence is exactly the situation that I just talked about. It's when you use things someone has done in the past to make it seem more likely that they would do the same thing or something similar in the future, or in the case that you're talking about in the moment. Now, what's unfortunate is that a lot of people, professors, teachers, scholars, if you will, want to make improper character evidence out to be something a whole lot more complicated than that. But I promise it's really not as difficult as they want it to be. And the situation that we just went through is a textbook example of improper character evidence that you can take to the bank 9 times out of 10. If you don't believe me, let's break down the actual rule for improper character evidence, talk about all of the terms inside of it, and then what I think we'll start to see is that improper character evidence really is as simple as, again, using things someone did in the past to make it seem more likely, or as a lot of people would say, that they have a propensity to do the same thing in the future. So the rule for improper character evidence comes in the Federal Rules of Evidence in Rule 404A, which says this: evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Now, when you just look at that rule on the surface, it can seem really complicated because it uses a lot of complex terms and phrases that we don't really naturally understand. So let's break down each of the most important phrases of that rule. And let's start with the first one: evidence of a person's character or character trait. Well, that one is really as simple as it sounds. It's evidence of a person's character or character trait. And here's what that means. It's talking about evidence of maybe things someone did in the past, or evidence that leads to someone being labeled with a specific character trait or label. So let's talk about the bank robbery example I used earlier. The bank robberies in the past would count as evidence of a person's character, right? It's evidence, it's things that happen, things we can talk about in a courtroom that point to someone having a certain type of character. A character trait would be if, instead of taking specific, as some legal scholars might call this, extrinsic examples, which, by the way, if you're getting that far into the weeds, you're probably way too far in. It's not that confusing, I promise. But using specific examples, that's one thing. And then when we talk about a character trait, that's when we simply give a character label. That's when we simply call someone a robber, a dangerous driver, an alcoholic, right? Those are all character traits, and it's usually evidence of character, things someone did in the past that point to those character traits. So Rule 404A starts by talking about evidence of a person's character or character trait, and what it's telling us is that that's the type of evidence we're dealing with this rule. Evidence of a person's character, things they've done to point to a character or a specific character trait. The next line of Rule 404A says that stuff is not admissible. Now, you probably didn't need me to translate that for you, but if you did, the translation of is not admissible means you cannot do it. It is not allowed. However, that's not all that the rule says. There is one more phrase that's going to help us to put a bow on this rule and really understand what it's getting at and what specifically is not admissible. So if the first two parts of Rule 404A that we looked at give us the type of evidence we're talking about when we're dealing with improper character evidence, the third part that we're about to look at tells us the how. It's telling us in the first two parts what type of evidence we're dealing with, and this third part tells us how we are not allowed to use it. And as a refresher, here's what that says. Again, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Now again, that's yet another phrase that sounds really overwhelming, right? To prove that on a particular occasion the person acted in accordance with the character, right? It sounds like some kind of legal professor that's wearing like a monocle, glasses that are a lot nerdier than the ones I'm wearing. I like to think the ones I'm wearing are pretty cool. Okay, that's beside the point. Here's what this means. You cannot use evidence, work with me here, of a person's character or character trait. Again, we talked about what that means. That is inadmissible if the reason you're using it is to prove that later on down the road, someone, as the rule says, acted in accordance with, in other words, followed that same character trait. So, let's break it down a little bit simpler. We know what evidence of a person's character or character trait is, right? Things that happened in the past or a specific character label that we want to slap onto someone is not admissible, cannot come in if the reason it's being used is to prove that on a particular occasion, which just means, again, sometime down the road, that person did something in accordance with, to follow, if you will, that character trait. So if we take this back to the bank robbery example, the fact that you robbed banks in the past is evidence of your character. All right, so what this rule is telling us is that that evidence of you robbing banks in the past is not admissible if we're using it to prove that later on down the road, you acted in accordance with that character trait. What would it mean if you were acting in accordance with that character trait? If you were following that character trait down the road, that would mean you were robbing banks again. So what the rule is telling us in that situation is evidence of the fact that you robbed banks before, which is the evidence of your character or character trait, is not admissible to prove that later on you also robbed a bank. When you break it down that way, it's a whole lot simpler. And there are a lot of ways you can take that. Let's say it was a drunk driving situation. Let's say one time in the past you got arrested for a DUI, and then later on down the road you're being accused of a DUI. But unlike the first one, which we'll say you actually did, this time you did not. And so the government wants to bring in evidence and say, hey, he or she got a DUI in the past. But they can't do that. They can't use something you did in the past, again, a character or character trait evidence, to prove that down the road you acted in accordance with that character trait. You did the same thing again. You followed in the footsteps of that character trait. That's all improper character evidence is. Like I said at the beginning, and like we've seen through Rule 404A, improper character evidence is quite simply using things someone did or sometimes things someone was in the past to make it seem more likely that they'd do the same thing or act the same way in the future. That's all it is. Now, you might be wondering, well, what if I want to use evidence of things someone did in the past for some other reason? That's a great question, and sometimes that's actually going to be allowed. Rule 404B gives some clarity on that, and we're not going to go into that in this video because for right now, I don't want you to get overwhelmed, and I just want you to be focused on understanding improper character evidence under that rule we looked at, Rule 404A. We'll get into Rule 404B some other time, but for now, just know, again, evidence of someone's character or character trait, in other words, something they did in the past or something they were in the past, is not admissible to prove that on a particular occasion, sometime down the road, they acted in accordance with that trait, or in other words, that it's more likely that they did the same thing or acted the same way again. That's all it is, and I know you can grasp that, and I know you can understand that.
Up next, we're going to talk about speculation and lack of personal knowledge objections. These are two rules that are attached at the hip But there is a bit of a difference between the two, and we're going to talk about that difference right now.
We're going to go through the nitty-gritty of lack of personal knowledge and speculation objections and talk about three things. First, we're going to talk about when to make those objections. We're going to talk about when not to make those objections. And then finally, we're going to talk about how to make those objections to make sure you are set up for success the next time you enter a competition and are thinking in the back of your head, should I object to speculation? Should I object to lack of personal knowledge? Soon, you're going to be able to know the answer to that question. So, you ready to hop in? Let's do it. All right, starting out with when you should object to speculation or lack of personal knowledge. Now, both of those objections are very similar. In fact, they both come from the same rule, which is Rule 602 of the Federal Rules of Evidence. But there is a bit of a distinction between them, and that's what I want to go over right here as we talk about when you should object to speculation or lack of personal knowledge. I think we all understand that in a general sense, speculation and lack of personal knowledge is when a witness is talking about things that they don't really know about, that they can't really know about. And so here's the distinction between the two. When those alarm bells are going off in your head as a witness is talking about things that they're not really that sure about, that they don't really know, and you're saying, well, which of these two should I object to? Here's the filter you can run it through. Object to lack of personal knowledge if a witness is talking about things that they don't know at all. Object to speculation if a witness is talking about things they don't know for sure. Let me give you some examples of those differences. Something that I don't know at all is what happened at a party that I was not at. Something that I don't know at all is what my dad was up to today because I have not talked to my dad today. Right? I don't know either of those things at all. I have no knowledge on those fronts. And because of that, if I were to get on the witness stand and talk about what my dad was up to today or what happened at a party that I wasn't at, the appropriate objection would be lack of personal knowledge because I would be talking about things that I don't know at all. Speculation, if I'm talking about things I don't know for sure, here are some things. I might speculate that a friend of mine who has been distanced lately is mad at me or hates me for some reason. I might speculate that someone who was late for work every day for a week is lazy and is snoozing their alarm clock every morning and really needs to do better in the mornings. So both of those were assumptions. They were things that I was speculating. And I very well may be right about both of those things, but we don't know for sure. And that's what makes them speculation. Because, yes, it's true that the guy who's been late every day for a week might have been lazy, he might have been snoozing his alarm clock. But it's also possible that his wife has been sick, and so he's been having to take his kids to school every morning, and so as a result, just for this week, he's been late for work. Right? Do you see how that works? The friend who's been distant lately, I could speculate that the reason they've been being distant is that they're mad at me, but there could be an entirely another reason behind that. And because of those things, because we don't know for sure, that's why it's not allowed under Rule 602, and that's why it's speculation. So, when a witness is talking about something they don't know at all, that's lack of personal knowledge. When they're talking about something that they don't know for sure, something that could be right, something that may even be a good guess, that's speculation. Because, again, it might seem right, but we don't know for sure, and that's what makes it speculation. So those are the scenarios when you should make the objection, when to object to speculation or lack of personal knowledge. Up next, let's talk about when not to object to speculation or lack of personal knowledge. There's really two main scenarios I want to give you to avoid making this objection during. Scenario number one is when an attorney on cross-examination, or on direct examination for that matter, is asking a witness a question, and the entire point of the question is to illustrate that the witness doesn't know something. All the time, attorneys will try to convince the jury of their side of the case by proving, hey, this guy doesn't really know what he's talking about. He doesn't know X, Y, or Z. Maybe you're cross-examining a policeman and you're pointing out he doesn't know when the crime occurred. He doesn't know what weapon was used, right? Those are big, important points. And so think about how silly it would look if an attorney is cross-examining a police officer and they say, officer, you don't know what murder weapon or what weapon was used to kill this person. And you stand up and say, objection, lack of personal knowledge. Well, duh, right? Of course they don't have personal knowledge. That was the whole point of the question. I've seen a lot of attorneys make this mistake, and it's honestly like embarrassing. If you've done that before, don't feel bad. We've all made mistakes. I've made plenty of them. I could tell you about tons of embarrassing mistakes I made during my mock trial career, but don't do it anymore. If the whole point of the question is to show that someone doesn't know something, don't make the objection. The judge will probably roll their eyes and make you sit down. That's scenario number one. Scenario number two, where you don't need to object to lack of personal knowledge or speculation, is when a witness might technically be speculating in the sense of they're talking about something they don't know for sure, but there's a really darn good chance that they're right. So, for example, let's go back to my example from earlier about the friend who's mad at me, or the friend who's being distant being mad at me, right? That's something that I'm speculating on. I don't know for sure. And it's really hard to know what exactly is causing the friend to be distant from me, so we don't like that. But what if we had something that was a bit more of a sure thing? Like I go and I'm around the friend and they look at me and roll their eyes and walk the other way. And every time I walk up to them, they move to somewhere else. And I start talking to them and their faces getting red and they're clenching their fists and they're looking really angry, right? Don't you think at that point we would be able to rationally make the conclusion that they're mad at me? Right, with the first one, we were jumping to conclusions based on a little fact that we didn't know for sure. But with that scenario, the person who's avoiding me in public, who's walking away, can't we kind of make the conclusion that they're mad at me? And especially if it's written in the case that they are, in fact, mad at the person, why are we objecting to that? No one is actually going to disagree that the person who is avoiding me at a party and intentionally walking the other direction is mad at me. Every person on the planet would agree with the truth of that statement. So why in the world would we object to it? It's just gamesmanship. It's just an interruption for the sake of interruption. Don't object in that scenario. All right, how to make lack of personal knowledge and speculation objections. Now, I talk all the time in some of my other videos and in my book about the importance of returning to the rule, RTR, on objections. And yes, that is the most important part of objections, of arguing objections, of winning objections. But with lack of personal knowledge and speculation, it's not really necessary. Because if you were to stand up and defend one of these objections or make one of these objections by saying, Your Honor, Rule 602 says witnesses cannot talk about things that they don't know about. Well, duh, right? Of course witnesses can't talk about things that they don't know about. That's the whole point of you saying the phrase lack of personal knowledge. It gets the point across. So in that situation, the judge doesn't need you to give an explanation, and you don't need to waste their time with one. So instead of the usual path I would tell you to take with an objection, here's what you can do. Stand up, say, objection, lack of personal knowledge. Again, you'd make that objection if they were talking about something they don't know at all. Or stand up and say, objection, speculation, if they were talking about things that they don't know for sure, and stop talking. Right? Just those two phrases, objection, speculation, objection, lack of personal knowledge. That's all you need. Because the judge is going to understand exactly what you're talking about, exactly the objection that you're making, and then you'll leave the other side to scramble and try to explain why what they're doing isn't what you say they're doing. So all you need are two phrases, right? Objection, speculation, objection, lack of personal knowledge, and just be ready to fight if it comes back to you. Listen to what the other side says in their response to your objection, and be ready to defend against it when it comes back to you. If you can do that, and remember to follow the other rules we talked about in this video, you're going to set yourself up to really excel with these types of objections and start controlling the courtroom like a mock trial master.
The final rule of evidence we're going to take a look at is Rule 701, which deals with improper opinion objections. What I'm going to give you now is 3 questions you can ask anytime someone is on the witness stand giving an opinion to see, is that opinion allowed for a non-expert witness, or is that the type of opinion that requires an expert? Here are those 3 questions.
All 3 of the questions we're going to be dealing with today derive straight from Rule 701, which is the rule of evidence that lets us know what is and is not acceptable as far as opinions from non-expert or lay witnesses. Here's what the rule has to say. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact and issue, and C, not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Now, there's a lot of big words in that, and it can be difficult to understand. That's why I'm giving you these three questions today, because they're really a translation of that rule into terms that it'll be really easy for you to understand. And so the first question you have to ask when you're deciding if an opinion is okay for a non-expert is this opinion rational? Is this opinion rational? Now, rational is a word that we use in everyday conversation. We'll say, oh, that's rational, or that's not rational. And what we mean when we're saying that is this thing reasonable, and is it easy to accept as true? In other words, would anyone hear that and go, yes, I agree with that? Let me give you a few examples. If you're outside in the heat of the summer, it's 95 degrees, and someone says, man, it is really hot out here, right? That is a rational opinion. That's an opinion that is reasonable and easy to accept as true. No one is going to dispute that. All right, let's change it up a little bit and talk about the springtime. Let's say that maybe it's in the low 60s, high 50s outside, and someone says, man, you know what? I'm really hot. Well, is that reasonable and easy to accept as true? Maybe, a lot of people, that's probably very, very comfortable weather for them. But you might have someone who's very warm-natured, and so they genuinely do feel warm out there in that 60-degree weather. And so it's maybe a little less rational than the first opinion, but I think we could all say it's reasonable and easy to accept that that person does feel warm if that's what they're saying. Now let's take it to wintertime. Let's say it's 15 degrees outside. There's snow falling. There's icicles hanging from the roof. And someone says, man, I'm burning up out here. Now we have a problem when it comes to rational, right? The opinion is no longer reasonable and no longer easy to accept as true. And that's the first hurdle that non-expert opinions have to cross. Is it a reasonable opinion? Is it easy to accept as true? The key word there coming from Rule 701, is it rational? Question number 2 you got to ask is this opinion a perception? Now, what do I mean by perception? Well, the root of that word perception is perceive. And when I think of that word perceive, I think of things that we take in through one of our 5 senses. So I walk outside where I live and I walk past the dumpster and I perceive that it smells awful out there by that dumpster. To return to the example we were using a minute ago, I walk outside during the summer and I perceive that it feels really, really hot. Right, the first one came through the sense of smell. The second one came through really a sense of touch, of that hot air, hitting my skin. When we're thinking that word perception, we're really limiting ourselves to things that we sense. Right, I go outside, I say, man, the sky is blue. That is a perception. It's something I'm taking in, I'm perceiving through one of my 5 senses. That's the type of opinion we're dealing with non-expert witnesses. Right, we talked about on the first hand, it has to be a rational opinion. It has to be one that is reasonable and pretty easy to accept as true. And then on the second hand, it has to be a perception. It can't be something that I've studied or spent a long time, concluding something based on information or materials. It's just something that I sense, something that I perceived. Doesn't necessarily have to be something you agree with, right? That was the example of it being 60 degrees outside. You might think it feels great. I might think it's hot. It's still rational and it's still something that I perceive. And so those are the first 2 barriers that an opinion has to cross for it to be okay for a non-expert witness. Now let's talk about the third and final barrier. Third and final question you need to ask of an opinion to see if it's okay for a non-expert witness is, does it require specialized knowledge? What do I mean by specialized knowledge? Well, by specialized knowledge, I mean the type of knowledge that you could only get through study or through experience. So, for example, doctors have specialized knowledge in medicine. They've studied it for years. They spent nearly a decade in school learning about the science of the body and biology and the way everything works together. And they probably have experience too, experience practicing medicine, working with patients, diagnosing, writing drug prescriptions, right? Doctors have that specialized knowledge. And so an opinion that's going to require specialized knowledge, a medical opinion, is going to fail that test because it's going to require specialized knowledge. But you don't even have to be a doctor or an expert scientist for specialized knowledge to apply to what you're doing. Think of an auto mechanic, right? There's a lot more auto mechanics than there are doctors out there. It doesn't take as much schooling. In some cases, it doesn't take schooling at all. But it's very specialized knowledge, because I can promise you that the automotive shop up the road from where I am right now, they know a whole lot more about cars than I do. They can perform a lot more repairs on cars than I could ever hope to possibly repair, because they have specialized knowledge. They've studied how cars work. They've studied the various parts and how they interact with each other and what it takes to fix them. And they have experience on top of that. They've done these jobs before. They know how to get them done quickly, efficiently, and well. And so that's the third question you've got to ask with these opinions, because if you're asking a witness for an opinion that really requires that study or that experience for the question to be answered well, it's not an opinion that non-experts are going to be able to give. Because if it requires that specialized knowledge, you need an expert witness. So let's recap all three questions all together. Question number one, is the opinion rational? Is it reasonable? Is it easy to accept as true? Question number two, is it based on perception? Is it something I perceived with one of my five senses, or is it something I had to really kind of study and figure out on my own? And then the third question is, does it require specialized knowledge? Do I need some kind of study or some kind of experience to be able to really fully accurately answer this question? Or is it something that just about anyone is going to be able to answer? If you're dealing with an opinion that is rational, is based on a perception, and doesn't require specialized knowledge, then you've got an opinion that a non-expert witness is allowed to give. Otherwise, you're going to need an expert witness. If you need an expert witness, that doesn't mean you're done. It doesn't mean you can't use the opinion. You just might need to set your witness up as an expert. And if you want to know how to do that, I made a video breaking that down. And to watch that video, you can click the link in the description below. But that's it for this one. Hope this was helpful in your upcoming objection arguments. Can't wait to hear how it goes.
You've officially made it through the ultimate guide to objections. And look, this stuff isn't easy. These rules have complicated language. They can be very dense. So if you watch this video and you say, okay, I understood most of this, but I might need a refresher, that's okay. Go back and watch it again. Go back to the specific parts of the video that you feel like didn't make a lot of sense. It takes time to really dig in and understand this stuff, but what I can promise you is that your effort will be rewarded. If you want an even deeper dive into objections and the rules of evidence, pick up a copy of my book, Mock Trial Masterclass. This is what students all over the country have used to sharpen their objection skills, get better with the rules of evidence. And you can pick up a copy by clicking the link in the description below. But that's it for the ultimate guide to the rules of evidence. I hope this was helpful. If you want the ultimate guide to objections, where I talk about the best strategies for arguing and winning objections, I'll leave a link to that below, and you can watch that next. Thanks for watching. See you guys next time.